Welcome to the Senate Judiciary Committee. We now have a quorum. We'll call the meeting to order. I'll ask Senator Parent if you want to open us up in a word of prayer. Mic 1, if you'll bow with us.
Sure. Dear Lord, please watch over us and guide us as we consider the work of the people of Georgia. Please, in your wisdom, guide us to do what is right for all of our constituents and all of the people that we represent. In your name we pray. Amen.
Thank you. There's a sign-up sheet for the two bills that we have on the agenda today. Thank you. And no one has signed up. Does anybody want to sign up to speak on these bills? All right. I will ask Senator Dixon if you'll please come up. You'll stand at that podium right there. We're going to start with Senate Bill 33. And I'll give you the floor. Tell us about the bill. Let me get you on. Hold on. There we go.
Okay. Thank you, Mr. Chairman and committee members, for having me here today to present Senate Bill 33. It's in regards to civil cause of action for a victim of human trafficking, also cause of action by the Attorney General. It creates a new code section to provide for a victim of human trafficking to have civil cause of action against a perpetrator to recover damages and reasonable attorney fees. It creates a statute of limitations for filing such civil actions, provides for a stay of civil lawsuit while any criminal action arising from the incident of human trafficking is pending, and provides for the Attorney General to have cause of action against a perpetrator of human trafficking on behalf of the state under certain circumstances.
Let me make sure, I should have done this when we started, I have the right LC number. It's LC 412797EC. Is that the LC
Yes, sir,
you're
Mr.
talking
Chairman.
about? Everybody have that one in their folder? Well, let's ask that's a good question. Someone asked what EC stands for. Senator, what does that stand for?
I would need to defer to Trey.
Well, this is your bill, isn't it?
Yes, it is.
Okay. Who's Trey? Is Trey the senator?
No, sir. He's with the governor's office.
Well, I don't think I had anybody sign up to speak, so I think it's just you. So
Okay.
let's try to get an answer to that one. This is your first bill, right?
It is, yes, sir. I apologize for not having the answer for that.
Yeah, in the future, try to know what your bill actually does. That is always helpful. Some committees, not so much, but Judiciary, yes.
Understood.
Those
My
health committees, you got to get by. Couple other things I had. You're not recognized. Isn't this the First Lady's bill?
Yes, sir, it is.
A word of advice as somebody that carried the First Lady's legislation last couple years, always start with that.
Okay. Noted.
That helps with your bill a little bit. Because some people have respect for the First Lady. You have respect for her, correct?
Yes, sir.
Okay.
Very much.
It'd be helpful if you mention that so people know it's her bill. I was looking at the signers on the bill. You have some big names on there. You have another freshman, Hatchett, Mullis, whoever that is, and then a Miller and a Jackson and others. And I wonder why I didn't sign the bill, because I thought it was a great bill. And I went and looked, and now online you can see every single person that signed a bill. Have y'all seen that? Yes. I was like number 58 on there. I was at the very, very bottom. I'm serious. I really was. Probably not 58. How many senators are there in the state Senate? Do you know?
56.
56. I was number 56. And the question is, why did you bring me the bill right before you filed it last minute like that versus asking me to sign it early on?
Definitely I guess a freshman or a rookie mistake.
Yeah.
My apologies.
That's okay. I'm not that important, but I was a floor leader, and I do chair the committee you're going in front of, so I'd like to.
Oh, yeah, you're very
bill.
important to me.
Yeah, obviously. We have
No
some other
mistake for
questions. Senator Parent?
Oh, goodness. I was actually just looking up myself to see what number you were on the signers list. Yeah, I can't decide if I'm pleased or disturbed by this new availability of information on signers. But I do have an actual question, which is I wanted to unpack the perpetrator a little bit more. Can you expound upon the types of individuals or entities that you think would end up being considered perpetrators under your bill?
Yeah, absolutely. So if you look under Section 1, and if you look at lines 14 through 16, that's where in the bill it defines what a perpetrator is, and it reads, a perpetrator means a person or entity that knowingly benefits financially or by receiving anything of value from participation in a venture or scheme which such person or entity or should have known involved a violation of this code, 16-5-46.
Very good reading, Senator. Okay, so I have a follow-up question if you'll indulge me, Mr. Chair. Okay, so
Go ahead,
do you
please.
think that this would include, for example, an apartment company or landlord, if they became aware that there was sex trafficking or human trafficking happening on the premises of the business or a hotel? Or is this intended to get more towards pimps and people even more directly related with human trafficking?
Yeah, no, great question. It could potentially encompass everyone that you stated if they were knowingly participating in human trafficking. And I guess an example for a hotel chain would be, if you had somebody that was not a one time coming in there and staying, but you saw the same person bringing children in, time and time again, and then somehow financially or directly benefiting from it.
So it is intended to be pretty broad.
Yes, but it's pretty specific, that they must be knowingly
They have to
contributing
actually
to
know
it.
what's going on and
Yes,
then be
ma'am.
getting some kind of
That's correct.
benefit. Does it have to be monetary? Anything of value? So no, it doesn't. Okay.
Well, the way that it's intended is not like they come in and they're coming into a store and they buy a bag of chips with money that they earn from human trafficking in some way. It would not encompass those folks, in my belief. It's if they're directly knowing of the human trafficking and they're involved in it and benefiting from it by actually making money off of it.
So so if they made like $2 and they bought a bag of chips,
Right.
that would not, in your estimation, be something of value.
I don't. Great question.
I
no,
suspect that, yes, maybe it would be like sort of a question for the court or the jury, whether it rose in value and no.
Yeah. Because an attorney, could claim anything, but would that hold up in a court of law? Would a judge convict somebody because they bought a bag of chips?
Oh, Senator, you're in front of Judiciary. Attorneys cannot claim anything. There are actual rules of the bar and requirements in you can't just say anything, otherwise you could be subject to sanctions.
Okay.
Yeah.
Noted.
Yeah, and then you can get disbarred. I'm done.
Dr. Watson, or is it Dr. Kirkpatrick? Dr. Kirkpatrick, you have a question?
I did have a question. Thank you, Mr. Chair. It's about the section that starts with line 23, about that an action may be brought within 10 years after the cause of action or the victim reaches 18 if the victim was a minor. So conceivably, the statute of limitations, I'm not very familiar with in this type of law, but is 10 years, would that be normal for this type of an action?
I do believe so. From what research has been done, as far as going to the 10 years from, if a minor had been trafficked, and they reach the age of 18, they have 10 years to file suit. From what studies have been done, the younger a child is, the more they bury that in their subconscious, and it takes them many, many more years, to come to grips or the realization of what had happened to them.
But if I could just follow up. So, but in number 1, line 25, it says 10 years after the cause of action arose. So that would imply that whether the victim was a minor or not, the statute of limitations would be 10 years. Is that correct? Because I'm
That is
more
correct.
familiar
Yes,
with
ma'am.
medical malpractice, and the statute of limitations is 2 years. So just clarifying that.
Yes, ma'am, that's correct.
Yeah, is the purpose of that, as you allude to, I know with minors, but also anybody that's a victim of something like this, it sometimes takes longer for someone to come forward or possibly get out of, I would say a lifestyle is the right way of putting it, but get out of that, being in that system, if you will, of human trafficking, and that allow, the purpose of the 10 years, I guess, is probably to allow additional time for someone to come forward and then have the ability to go after them civilly. Is that right?
Yes, sir.
And this bill just creates a civil cause of action, which requires somebody to file a lawsuit in our superior courts, correct?
Yes, sir, that's
And
correct.
so someone would still have to go and put this in front of a jury. This is not someone bringing a criminal charge. This is actually a civil cause of action that would go in front of a jury or a judge that they chose in our state, correct?
Yes, sir.
Senator Kennedy?
Thank you, Mr. Chairman. Senator, just a couple of questions. Not as entertaining as some of the earlier ones that you got today, but so in looking at lines 30 and 31, and this deals with the Attorney General's having a cause of action as referenced on line 30, which to me sounds like a civil cause of action. So I assume it would be the pursuit of civil remedies versus some sort of criminal action. And if that's the case, my question is, when you add that language, the civil cause of action against such perpetrator on behalf of the state to obtain appropriate relief, does that language supplement what the victim is able to do in pursuing their civil causes of action, or is it intended to be separate?
I believe it's intended to be separate.
Okay. Can you, and I'm supportive of the bill. I like this. This sounds good. But what sort of relief would be envisioned or was envisioned when the drafters were working on the bill? It says obtain appropriate relief, and we're talking about a cause of action, so we're thinking the pursuit of a civil remedy, right, to obtain appropriate relief. What is it that what was envisioned or what might typically flow from the Attorney General pursuing the perpetrator on behalf of the estate?
Yeah, no, great question. Would like to call on, if you may, Mr. Chairman,
Yeah.
Trey Bennett from the Governor's Office.
Mr. Bennett, if you want, why don't you come to mic 6 here, and then we could have y'all both live, and we'll have everything you say versus y'all trying to share that podium. You could stay there, Senator. Do you want to directly introduce yourself, if you'll address that?
Sure.
question?
I'm Trey Bennett. I'm in the Executive Counsel's office for the Governor Kemp. Senator Kennedy, this is actually, this bill is almost word for word the federal statute. So we're bringing home a federal cause of action for it to apply in our state courts for actors that wouldn't qualify for jurisdiction under the federal code. So in E, instead of Attorney General, they would have the United States Attorney. What we believe and what we've seen is if we needed injunctive relief to potentially close a hotel that's repeatedly offending over and over and over again, something like that, I don't know that this cause of action would supplant a private cause of action. I don't think if the Attorney General files under this code section that it would bar a victim from actually also suing.
Okay. Mr. Chairman, may I follow up? Thank you, Mr. Bennett. I appreciate that. I think that helps, but it kind of prompts another question. If the idea is that the Attorney General would have the ability to close down a hotel, I'm concerned about the language on line 20 because it says the cause of action the AG has is against the perpetrator. Would the hotel perhaps fall in within the definition of a perpetrator as this statute is written?
It could potentially. Under the definition of perpetrator, you have individual or entity that is knowingly engaged in the systematic, I could read the language for you, but is knowingly engaged in the scheme itself. It's similar to the criminal RICO statute is the language that they've used under the civil context to define who a perpetrator is.
Okay. Thank you. Thank you, Mr. Chairman.
Yes, one more question, Mr. Bennett, talking about the federal language. That 10-year statute of limitations, is that the same that's used under federal law as
It
well?
is.
Okay. Senator,
Thank you, Mr. Chairman. Question for you, Mr. Bennett, and thanks for being with us. So on line 14, you've got the perpetrator knowingly benefits, person or entity knowingly benefits. On 16, we've got knew or should have known. How are you squaring those?
Again, that's the federal language, and it could potentially be a little bit excessive, but what it would eliminate is the opportunity for someone to say, if you remove that first knowingly, you could say it means a person or entity that benefits financially. Say again, like the analysis of when you mentioned the bag of chips. Okay, well, the gas station employee received $2 for the bag of chips that came some way down the line from an act of human trafficking. Here you would have to knowingly benefit from that act of human trafficking. So I guess potentially if the employee knew and provided cover for, facilitated the transaction of human trafficking, and then knew that those finances were then used to purchase the product at the store, you could have some type of liability, but you have to knowingly participate and knowingly benefit. So, I mean, you could see a hypothetical situation where you knowingly participate but not know that you're going to receive benefit.
Can I ask a follow-up? It seems to me that it would be, you have to know you got a benefit, but you don't necessarily have to have known that you are participating in the scheme. So like, to me, that would be more like, say I'm running, an apartment complex or something, and I'm seeing what should have set off alarms with lots of, say, underage people at all hours and, just other signs that something was amiss. And I know I'm getting money from that, but I don't necessarily know exactly what's going on, but I should have known. So I feel like that's what it's intended to kind of.
And you would
Okay.
qualify under that
Okay, thank you.
as a perpetrator.
Senator Cowsert?
Thank you, Mr. Chairman. Back to the Senator Kennedy's questions on line 31 of what the appropriate relief is. You mentioned injunctive relief. Are there other types of appropriate relief? I mean, I'm assuming this is not monetary damages since that right is given to the victim. Is it more than just an injunction? If not, why don't we just change that to obtain injunctive relief?
Again, that's federal language, so I assume that there could be a civil forfeiture aspect there as well. But I believe that's why they left it broad in the federal sense, and that's why we've adopted it here.
Are you aware of examples of the U.S. Attorney General, whoever has this right under federal law, suing the perpetrators as you've defined them, people benefiting from the
I am aware of trafficking being a forfeiture qualification offense under state and federal law, so I believe that may be another way that it's used. So.
Okay. Thank you.
Dr. Watson?
Thank you. Don't need those anyway. Just for my education, so knowingly means should have known.
No.
Does not. Okay. So it doesn't necessarily mean that. So knowingly does not mean should have known.
Well,
Is the opposite true?
if I could refer you to 14 through 16, the definition says that they knowingly benefit
Right.
from a transaction that they knew or should have known involved a violation.
Okay, I got you. Okay,
So you
thank
have the
you.
knew or should have known
Should have known.
in the participation.
Appreciate that. Thank you for you. And could I have one follow-up?
You're starting to really enjoy judiciary with questions
Yeah, I
like
tell
that.
you what, goodness gracious. I can talk about vaccines if you want me to, but follow up just for my education. So the 10 years, does that mean if the victim comes to 18 years old, does that mean they can file up until 28, or am I reading that wrong?
So yes, under this statute, you have 10 years from the age of 18 if they were a victim at any point before they
Gotcha.
reached the age of 18.
Makes sense. Thank you.
Any other members of the committee have a question for the author or Mr. Bennett? And so I think someone from the GBI wanted to speak. Is that correct?
That's correct, sir.
You want to come forward?
Yes, sir.
You can go, well, come on up to number 7. That'll work.
Good afternoon, everyone. My name is John Melvin. I'm the Assistant Director of the GBI, but I was also a prosecutor for 25 years before I went to the Bureau. And I appreciate the questions that the Senate asked. I wanted to let you know that the Bureau stands wholly behind this bill. One of the questions that you asked, Senator Parrott, really touches on a legal argument called deliberate ignorance, which prosecutors have to face all the time. Like the classic case is a man who constantly gets boxes and then gets paid $200 per box, but he never says, why am I getting these boxes? And somebody else comes and picks them up. And of course, that guy's involved in trafficking of drugs. In situations like this, and when I was with Cobb County for a number of years, we actually had local motel chains facilitating the trafficking of young adults. And when we're talking about appropriate relief, not only are we talking about adjunctive relief, but what Mr. Kirkpatrick said is the ability to shut down and forfeit these hotels that are facilitating it. And when we get to the knowing and should have known, they have to knowingly participate, but the should have known kind of forgoes that deliberate ignorance of, yeah, we've seen young women go in and out all day. We've seen Johns go in and out all day, but we didn't know what was going on, and that will forestall that kind of very common defense that is used.
Thank you.
Yes, ma'am.
Anybody have any questions? All right, thank you.
Thank you, sir.
Anybody else want to be heard on the bill? This time we'll take motions. We have a motion to pass by Senator Watson. Second by Senator Parent. Any discussion? All those in favor of the motion, please raise your hand. All those opposed? Passes unanimously. Thank you.
Thank you very much.
Congratulations on your first bill. You pick a light subject and easy committee for your first one, right? Now we have round
Thank you for
2.
being so accommodating.
If you want to stay up here, Mr. Bennett, if you'd like for him to stay up here for the next bill as well.
Yes, sir,
We
Mr.
have
Chairman,
Senate-
that'd be great.
Senate Bill 34.
Yes, sir, Mr. Chairman and committee members, thank you for allowing me to present Senate Bill 34 to you today. It is a First Lady's bill,
There you go.
who I respect very much.
There you go.
This one deals with human trafficking victims being able to petition for a name change. It provides a victim of human trafficking to petition the court for a name change and file the petition under seal, where it would be sealed and would not be publicized in the paper. This particular bill, it mimics the or follows a victim of family violence. They're allowed to petition the court for the same seal if they go for a name change. This bill, it permits the court to issue an order waiving the requirements of publication related to a petition name change if the court determines the petitioner a victim of human trafficking. It also allows the court to later unseal the petition or order the redacted version of the petition for the public record.
And so someone that wants to use this code section would have to actually file a petition with the court, is that correct?
Yes, sir, Mr. Chairman, that's correct.
And then the court has a discretion whether or not to grant that. So
That's
someone
correct.
couldn't just abuse this. It actually would be some sort of finding by a court that it's appropriate, is that correct?
That's correct.
Dr. Kirkpatrick?
If you don't mind, Mr. Chairman, I had a question about the normal process and how that's different, and that's just for my own education. You said something about putting a notice in the paper. What else has to happen if the name change is not under seal?
Yes, I mean, they have to put a notice in the paper. It's from my understanding for creditors or anyone else that would need to be, publicly notified of a person changing their name.
That's it.
Yes, that's correct.
Well, and I guess the bill also makes sure the filing itself of the name change would not be public record as well with the court, correct?
That's correct.
Okay.
Yes, sir. You are correct.
Senator Parent?
Yeah, thank you, Mr. Chairman. I'm actually a little surprised that we don't already have other forms of persecution, this sort of procedure allowed for other situations where people are being persecuted. And I was just curious, though, are there examples that we know of that sort of prompted the bill where, I mean, is this more common that people feel like they need to hide in a human trafficking situation versus other forms of persecution? I'm assuming y'all have some data on that or something.
Yeah, I'll let Trey Bennett answer that.
Thank you.
I don't have data. We do have some anecdotal stories of survivors that have reached out to the First Lady via the Grace Commission and our staff. One thing that is pretty common for these individuals is, especially young women, when they are rescued or they come out of a human trafficking situation, one of the first things they want to do is change their name so that they can avoid not just their trafficker, but their prior associates and abusers. And currently, the individual who brought this to our attention specifically has a suit filed. She is concerned about her safety because she was trafficked under gang-associated situations. And she is actually also a victim of domestic violence. So she is filing under the domestic violence provision here to avoid having to announce to the world for several weeks her former name, what her new name will be, where she's filing, which could indicate where she is located now. So that was, this is a direct idea from a survivor that was brought to our attention, and it is a relatively common problem that these individuals have.
And I've got a story, if I may share it. In my district, our former sheriff had shared this story with me after learning, that I was carrying these bills, and said that there was a family, a young lady was dating somebody that was involved in one of these rings, and it was a gang. She became hooked on drugs. They trafficked her, got to a hotel right near Lawrenceville, Swanee, in 85, and she was on the way to be shipped out when they came in and raided this particular hotel and saved her from it. And the family, they have moved and had to, they're trying to, basically they've had to change their identity because their fear of retribution from the ring, because it's not always just a single individual. It's typically a pretty, big network, that operate these things.
Thank you.
Anybody else have any questions for the author, Mr. Bennett? And I once again messed up. We're on LC 412682 EC, correct?
Yes, sir.
Okay. Supposed to say that at the beginning. Dr. Kirkpatrick,
At the appropriate time, Mr. Chair, I'd like to make a motion to pass.
before you do that, is there nobody else signed up to be heard on this bill? Does anybody want to be heard on this bill? All right, now you can make the motion.
Move to pass on LC 412682-EC.
Motion do pass by Senator Kirkpatrick, a second by Senator Rhett. Any discussion? All those in favor, please raise your hand. Passes unanimously. Congratulations, and all jokes aside, good work on this. It's definitely some heavy lifting in your first bills to get involved in this, but we appreciate the work you're doing, appreciate the work of our First Lady ever since she's been in this office, taking on this industry in our state. I will say this, though, when I had a bill with the First Lady, she actually came on the floor of the Senate as I presented the bill. So let's see if you can top that with these bills.
I will do my best, sir.
All right, thank you. And with that, we are adjourned. Thank you.